All right, today we're jumping right into a really fascinating debate, one that sits at the crossroads of biology, law, and, you guessed it, economics. This is a question that just recently made its way to India's highest court, and believe me, it has sparked a massive conversation all across the country about women's health in the workplace.
And really, it all comes down to this one really powerful question. Should period pain mean paid leave? Should it be a legal right? Or could it actually unintentionally end up harming women's careers? That's the huge tension we're going to unpack right now.
And here you go. This headline right here is what brought the whole thing to a head. You've got India's Supreme Court weighing in, and they voiced a really serious concern. They asked, could a law that's meant to help women actually end up hurting their job prospects? It's a huge paradox, and that's exactly what we're going to explore.
Okay, so first things first, let's look at the argument for this, the yes side. Why did this even land in the Supreme Court in the first place? Well, it was all framed as a fundamental issue of health and, importantly, equality.
So the whole thing started with a petition filed by an advocate named Shailandra Mani Tripathi. His argument was pretty straightforward. The law needs to officially recognize the very real, often debilitating pain that working women experience.
And what's really key to understand here is that this argument was grounded in real medical science. We're not just talking about general discomfort. No, the petition specifically called out severe, debilitating conditions. Things like dysmenorrhea, which is the clinical term for incredibly painful periods, and endometriosis, which, for many, can literally make it impossible to work.
But this wasn't just a health argument. It went much deeper. It was framed as a constitutional issue. The petitioner argued that denying this kind of leave actually violates two fundamental rights in the Indian Constitution, Article 14, which is the right to equality, and Article 21, the right to life and personal dignity. And the question they put to the court was simple but powerful. How can you really have dignity at work if you're being forced to just push through severe, debilitating pain?
And, they also pointed out that this idea isn't some brand new, radical concept. Look at this timeline. We're talking about decades of precedent. Japan had a law for this way back in 1947. South Korea followed soon after, and even within India, the state of Bihar has had a policy since 1992. The point they were making was crystal clear. This isn't just a theory. It's something that has been put into practice, and it works.
But then, everything changed. There was this one moment, this single quote from the Chief Justice of India that just completely shifted the entire conversation. It cuts right to the heart of the fear on the other side of this whole debate.
And that quote brings us right to the court's main argument, the big but. The judges started framing this idea of mandatory leave not as a right, but as a potential risk. They worried it could actually be, in their words, counterproductive to the goal of women's empowerment.
So what were their specific reservations? Well, the court's concern wasn't really about denying the biological reality of pain. Not at all. It was about the cold, hard economic reality of the job market. The fear was this: if you force companies to provide this extra leave specifically for women, what's to stop them from just hiring fewer women to begin with? It's a scary thought, right? That a policy designed to help could ironically end up reinforcing those old, tired stereotypes.
Now, here's a really important distinction to make. The court wasn't against the idea of menstrual leave in principle. In fact, the Chief Justice went out of his way to call voluntary policies, where companies choose to offer it, excellent. The sticking point for them, the real problem, was the idea of a mandatory law that would be forced onto every single employer out there.
And this slide just sums up the whole tension perfectly, doesn't it? On one hand, you have the petitioner's argument, which is all about a biological reality that needs to be recognized as a matter of health and dignity. And on the other hand, you have the court's concern, a real-world fear about creating a disincentive for hiring women and a risk of making things worse. This right here, this is the absolute heart of the debate.
So where did all of this land? After hearing both of these powerful arguments, what did the court decide? Well, their final verdict wasn't a simple yes or no. It was actually a redirection of responsibility.
Basically, the court decided that this whole thing is a super complex policy issue, and not really something that can be solved with a judicial order. So they disposed of the petition, which is a legal way of saying, you know what, this isn't really our job to decide. And instead, they pointed the finger directly at the government to figure it out.
And just for a little bit of context, this wasn't the first time this came up. It was actually the third writ petition filed by the same petitioner on this exact issue.
So you can see there's a really determined, persistent effort here to get a solid legal ruling on something that, up until now, has just been a policy question.
So the ball is now officially in the government's court. Specifically, the Supreme Court has tasked the Union Ministry of Women and Child Development with looking into this. They've been told to consult with everyone involved. We're talking employers, women's groups, all the stakeholders, to figure out if a national policy is even feasible.
Which, of course, leaves us with this giant unresolved dilemma. The legal case might be over for now, but the actual problem hasn't gone away. So what's next? What are the potential paths forward from here?
Well, instead of one single sweeping law, maybe a multi-pronged approach is the way to go. You could, for example, really promote those excellent voluntary policies the court talked about. Or how about just strengthening paid sick leave for everybody, regardless of gender? Another idea is to let different states experiment with their own policies, gather some data, and see what actually works best before even thinking about a national mandate.
And really, that's the big question we're all left with, isn't it? It's the ultimate balancing act. How can a society support women's health in a meaningful way without accidentally harming their careers in the process? There is absolutely no easy answer here, and one thing is for sure, this conversation is far, far from over.